fixing my learned and I have said that the notice accordingly. Government should be verified. So for that, I on the last occasion I said that my lord may give some time to submit a written note, and I call written note has been prepared. So your lordship can just look at written note and submit. Try to dispose of yes. If my I will inform the other side. So I will try it for part. Like your lordship can go. Wait, please also. So I pray for listing of a matter, a press matter for tomorrow, Lordship. Why? It's an urgent matter because there's an interview this Monday, coming Monday, Lordship, for the post of associate officer. And because my application for age relaxation has been pending, kept pending, now I am at a situation I'll not be able to take part in the interview. The interview is on the Monday, second Monday, Lord. I have filed my application for age relaxation. It's pending with the filed your petition. I filed it yesterday only. Obliged.
I have also similar prayer, my lord. I am also praying for listing of a matter tomorrow, my lord. What happens in this case, my lord, matter in this selection of my lord.
Motion matter.
Motion matter, my lord.
Fresh motion.
My lord.
Fresh motion.
Fresh motion, my lord, tomorrow. Obliged, my lord. Similar prayer.
Second.
The time will be over by Sunday.
Sunday. What matter?
In the defense proceeding, I have been asked to sue the person, my lord, that are control of the defense proceeding, my lord.
I don't know.
And defense, I have been asked to sue the official under the control of a defense.
The defense.
Yes, as a defense. And one of the president has been appointed. He was the listed witness in the so-called notice. I am challenging.
But when is the date fixed?
As a face matter. On last Sunday, the office has been charged to me. The time will be over by Sunday.
Have you read that listed witness therefore cannot?
There's another issue also. After submission of my reference against the second so-called notice, I'm selling the
Monday.
I'd like to mention item number 13 of today's daily list. Yes, sir. There's some difficulty on our end.
Yes.
Yes, sir. Or 70.
Thank you.
The consent of the other side, I take to mention item number 12. In this case, we got the affidavit yesterday only. So, today will be given
Item number
20.
20.
I very
Your body.
Respondent, private respondent.
Private. For the petition.
I'm for petition.
Please, time will be given.
It can be taken on 13 of March.
Can it be on 17?
So it can be, then it has to be on 26 or 20.
Can it be 24th?
Yes, 24. That doesn't matter, 26. Why? Why? Huh?
I said,
Respondent is appearing there.
I said I have no objections to your mentioning. Do not put it on my mouth. I have no objection if they are seeking, because they have won some accommodation today. Their senior
Item
counsel,
70
arguing
from
counsel
the
is not
request made by the county.
calling them in.
Pending complaint. Direction. Wireless or radio operator.
Yes, yes.
That matter. Cipher. Counsel would respond. Stop. Admission matters. Parts.
Long pending case, was factor is also there, my lord. For cases, have the cost one. What should be the exercising power under section 11(6)? Section 11(6) does not say that the appointment should be made as per the agreement.
It doesn't say, but it doesn't. Liberty also.
Yes, liberty.
The power of sections 11(6) is essentially to see whether there is a valid agreement or not.
Yes.
The arbitrators.
Even though my lord, the lordship may appoint the sole arbiter. Honorable Supreme Court also said, for saving the cost is also one of the factors.
Arbitration.
Also followed the Honorable Court. Paragraph.
What was the grievance of the respondent?
And earlier, my lord, they raised the issue relating to this the center organization case, my lord. Only that issue was there.
One of the express section 15 minor, 15 to minor, where the mandate of an arbitrator terminates the substitute arbitrator shall be appointed according to the rules that were applicable to the appointment of the arbitrator being replaced. There were three arbitrators there, my lord, one were transferred out. So, my lord, we wanted to replace it. But he is saying that since coming of the amendment of the Act, this is not permissible. But my lord, this is, my lord, the court judgment also said, my lord, that this judgment will have prospective effect, not retrospective. My lord, placement of my lord, substitution, my lord, petition is itself not making.
Section 12(5) came into force in 2015 itself. They themselves issued a letter for waiving the condition as mentioned in section 12(5). Now they are taking another stand at this stage. After expiry of the 1 year, there was no extension. So already it has gone. There is no arbitrators. They have been ceased to be arbitrators. The eye of law, there is no arbitrator. No arbitrator. After expiry of 1 year.
What has been done?
My lord, the inspector, find my lord, we find SOD, my lord.
Tribunal
Yes,
appointed. Was there any award?
No.
One after another, they change the
29A time limit has expired.
No, my lord, that 29A also subsequently came. When my lord, the was my lord, this arbitration appointed, my lord, that amendment was not.
There was some authority that 29A.
But it is written here, my lord. 29A itself says, my lord. It is prospective effect, my lord. My lord, kindly see, my lord. Effect from my lord 23/10/2015. Effective.
my lord, section 29A is applicable in all pending cases. Whether appointment was made after
Which provision?
My lord, when my lord, with effect from my lord.
Which
My lord,
section?
29A, my lord.
Ah.
Down below, my lord. 2, my lord. It is.
What is made? Read the section.
My lord. The award in the matter other than international commercial application shall be made by arbitral tribunal within a period of 12 months from the date of completion of the subsection section 20. Provided that the award, the manner of the in the matter of international commercial arbitration may be made as expeditiously as possible, and endeavor may be made to dispose of the matter within a period of 12 months from the date of completion of the pleading. And subsection 4 of section 23. If the award is made within a period of 6 months from the date of arbitral tribunal enters upon the reference, the arbitral tribunal shall be entitled to receive such amount of additional fees as the parties may agree.
According to you, section is not applicable because it has subsequent.
And I have come, my lord, with effect for my lord, 2010-2000.
That is not applicable by some authority, by some interpretation, merely because it does not say that it will not be applicable for, it doesn't exclude. Otherwise, it would have excluded.
Section 29A, my lord, this is a procedural matter, and this is applicable in the all pending cases. Here the arbitrators were appointed on 5/1/2016. By that time it was there. After appointment, they can start the proceeding, arbitration proceeding. For appointment, there is no question of
When were they appointed?
on 5/1/2016. At page 1,
2000. Why do you say it was prior to?
page 164, my lord. Sometimes he appears in.
I can remember two, my lord. Why you are one and two, my lord, both are called together, my lord. My colleague.
Page 164, my lord. Here the appointment was, first appointment was made, my lord. 5/1/2016. That day, within 1 year, the arbitrators should have passed the award. After expiry of, my lord, 1 year, they were ceased to be arbitrated.
Yes, what is submit?
Actually, they were agreed to attend the arbitration was appointed. But later on, they refused.
Where is the consent? Where is the consent?
One for time. Appointed lawsuit. Thereafter, one of the arbitrators was resigned. Thereafter, will
Where is that consent? So, have you bags, please,
Yes, my
supply?
no, my lord, I will supply. That will be better.
It and share it with your colleagues.
Yes.
They have any objection? You're not really inclined to assess the court. This matter again after. Of the facts. Thank you.
My learning colleague's name was directed to be reflected as he is standing on. A copy may be furnished to us. I will not take instruction
What copy?
of the contempt petition.
Not any party.
Because the contemptor has not really changed. The incumbent has changed, which is why
Can you serve him a copy? It's no copy.
This subject 21 is along with the item 9.
So IA is filed for amendment.
It's a small amendment, minor amendment. We are
What is the minor? How minor?
my lord, this we pray for to add one, my lord, prayer in the
Any who is for the respondent here? The state alone.
is the state alone.
Any objections? Any objection?
Just one paragraph in the first title, challenging the legality and validity of the departmental inquiry number 22. And the
Mr.
Actually, not say I have gone to the main case. The IA and also I have not gone to it.
Not one.
Regarding
Mr. CPS Guru. Nine.
then my lord 19 will also. Problem.
the affidavit opposition file.
Lordship, IA, they filed, that IA themselves, they had actually admitted in the IA that the selection process was at the end of the conclusion. So let me take a step on whether it has concluded. It has concluded. The petitioner.
What is this prayer?
My prayer is that a person to advertisement, my lord, the year 2000, my lord. We are selected, my lord, as per advertisement 26/6/2000, my lord. Some of the candidates, my lord, after selection were appointed, my lord, were left out, my lord, but a process is going on, my lord. Subsequently, this new advertisement published, my lord, in the year 20, and in view of this new advertisement also applied for. Some, my lord, preference may be because we are the eligible earlier also, my lord. And this verification was also done. But some of the candidates have been already appointed and also enhanced salary also, along with us, my lord. Some should be taken. The year 2000, my lord, advertisement. 2005 appointed, my lord. The year 2005, some of the selected candidates were appointed. But where, my lord, they are processing because, my lord, new advertisement was not published till the year 2020. Annexure 18, I have annexed the 2023 advertisement. In view of this 2023 advertisement, some of the candidates have been, my lord, adjusted. Those are selected and appointed. But that judgment also I have annexed. It was considered up to the age of 65 years. Those are the candidates who has not completed 65 years, they can.
And just saying selection. If I may take your lordship to para number 13. Telling and the Honorable Court directed us to go ahead with the whole advertising process, apart from leaving apart the 66 court, which the petitioners in that case are telling. And this judgment was restricted only to those 66 petitioners, giving us leeway to go ahead with the whole selection process. That's the other court. We went ahead. The petitioners, they participated in, and they had appeared in the interview as stated in their own IE. Now the only question that remains whether they have been selected in the interview process or not. If not, then nothing remains. If yes, then they have they will be selected as counselors.
Because, my lord, we are, my lord, waiting to be, because, my lord, earlier prayer also there, my lord, and they have processed, my lord, up to the some letters I have annexed, my lord. Annexure of these letter is, my lord. Annexure 9.
How should you get the instructions?
Also, next week, when it
State council, state. Subsequent selection process is undertaken.
also
11th.
The advertisement dated 24/20.
Advertisement selection and appointment pursuant to advertisement dated
24/2023.
004. It's not 11.
And
Please, I have a preliminary submission. I think it merits some affirmation from the other side also. What we recollect, these are issues pertaining to the fixation of pension under the EPF Act. there is a judgment of the Supreme Court in 2022, and I'm not arguing on merits at all. I'm just giving a brief background. 2022, their lordships passed a series of mutually exclusive directions. As commissioners, it was our job to categorize the beneficiaries and slot them into one or the other direction and accordingly fix their pension. Error which we committed, and I can concede that upfront, is that the pension fixation has not been accompanied with a speaking order, which is what prompted your lordship in December stay the fixation of pension because the petitioner's pension was reduced. May I request my lord to please have, if my lord may have item 6, which is Shyam Sundar Kalita versus Union of India. Suggesting a proposal which may shorten the controversy.
Yes.
Supreme Court's decision starts at page 100. And my lord, may please have the directions which are at the end of this judgment. My lord, may please have page 146. May I place Roman 3 there? The employees who had exercised option under the proviso to para 11.3 of the 1995 scheme and continued to be in service as on 1st September 14 will be guided by the amended provisions of paragraph 11.4 of the pension. What this essentially says is, this 11.3 mentioned there, my lord, it had an option. People could opt either for PF or for pension under this provision. So Roman 3 says those who had opted under 11.3 for PF must abide by their option. They cannot now switch over to pension. Now 4 is an order under Article 142 of the Constitution. 4 says members of the scheme who did not exercise the option as contemplated in the proviso to para 11.3 of the pension scheme as it was before the 2014 amendment would be entitled to exercise option under para 11.4 of the post-amendment scheme. Their right to exercise the option before 1st September 14 stood crystallized in the judgment of this court in R.C. Gupta. The scheme as it stood before 1st September 14 did not provide for any cut-off date, and those members shall be entitled to exercise the option in terms of para 11.4 of the scheme as it stands. Their exercise of option shall be in the nature of joint options covering pre-amended para 11.3 as also amended para 11.4 of the pension scheme. And then the rationale, my lord, there was uncertainty as regards the validity of the post-amendment scheme, which was quashed by the aforesaid judgments of the 3 high courts. Thus, all the employees who did not exercise the option but were entitled to do so but could not due to the interpretation and cut-off date by the authorities or to further chance to exercise them. So under 142, their lordships recognized that there were conflicting decisions of different high courts. They said that those who couldn't because of some indecision can now do that. Now this entire controversy before my lord today is whether the petitioners fall under 3 or 4. Their contention is they fall under 4, they must be given the benefit of this Article 142 direction. Our contention is they fall under 3. But whatever it is, I represent employees PF organization. The commissioner under the act has to decide whether they fall under 3 or 4. Now, my submission subject to my lord's consideration is this. We should have passed the speaking order entailing the reasons why we placed them under 3 and not under 4. We didn't do that, which is why this confusion arose. My submission is, my lord will remand the matter to us. We'll pass a speaking order forthwith, which we'll reconsider their issue, we'll consider their writ petition, we'll give them a hearing as well. Once that order is there, if they are still dissatisfied, my lord can review it under certiorari. That is my submission.
So essentially, you are saying
Yes.
that revisit your order.
There is no order. That is the problem. I was instructed in my lord.
Revisit the process,
Yes, really.
but not the conclusion.
My lord, we'll give reasons. So there may be in this entire batch people who may fall under 4 or people who fall under 3. It's a batch of
Where is that? That exercise undertaken by your client.
the commissioner had decided that.
Where is that?
Well, that is not. So there was no order as such. So the
He
petitioner.
simply decided to make the change the financial.
Yes, the
requirement.
quantum of pension was altered. So the PPO, the pension payment order, was revised. My submission is they should have passed a speaking order, because if it prejudiced the petitioner's right, there ought to have been a speaking order. Now, this exercise was done on a pan-India basis by different offices of PPO. Everywhere there are speaking orders. An anomaly occurred here. When
This is for the Eastern region.
this is the regional office, Gauhati. So we are cognizant of that error. We are ready to cure it immediately.
Yes, Mr. I have to argue this. You have want to say that you fall under.
The problem is, subject to my lord's consent, my lord were to see the correctness of our decision. In our affidavit, we have explained everything. But in my limited understanding, it should have also formed the basis of an order, which can then be viewed under certiorari by my lord.
Let me argue this.
Yes. So
he wants to argue this matter. Very remanded.
if we were to reconsider this entire issue, then my lord would remand it without expressing any opinion on the merits. If he wants a remand with my lord's direction, then it's a fait accompli for us.
You cannot compel us.
Not at all, not at all. This was only a submission. Then we'll argue the matter. Then we will.
Not accepting your proposal. And considering our
In order to resolve the issue, sir, I will let you. Section 6. Contribution and matters which may be provided the scheme. Contribution which shall be paid by an employer, the fund shall be the 10%, of the basic wages, dearness allowance, and retaining allowance, if any, for the time being payable to each of the employees, whether employed by him directly or through a contractor. And the employee's contribution shall be equal to the contribution payable to the by the employer in respect of him, and may any employee desire the amount exceeding 10% of his basic wage, dearness allowance, and retaining allowance, if any, subject to the condition that the employer shall not, under an obligation, pay the contribution over and above this contribution payable under this. That the employee's 10% wages, basic and dearness allowance shall be deducted for towards his provident fund, and similar amount shall be contributed by the employer towards the provident fund. There is a provision in this section, and this proviso is that provided that in its application to an establishment or class of establishment, which the central government, after making inquiry
as deemed fit, may by notification in the official gazette specify this section shall be subject to the modification that for the words 10% at both places where they occur, the words 12% shall be substituted. Therefore, in certain cases, 12% may be allowed, but subject to the approval of the appropriate government. That is the basic scheme under section 6. Now, below, in order to implement the provisions of the Employees Provident Fund and Miscellaneous Provisions Act 1952, there shall be a scheme to be formulated, and the formulation of that scheme has been provided under section 5. The Lordship may kindly go to the section. Employees for the implementation of the Provident Fund and Miscellaneous Act 1952. Employees Provident Fund scheme. The central government may by notification the official gazette frame a scheme to be called the Employees Provident Fund scheme for the establishment of provident funds under this act for the employees or any class of employees and specify the establishment or class of establishments to which the said scheme shall apply, and there shall be established as soon as may be after the framing of the scheme a fund in accordance with the provisions of this act and this scheme. Thereby, the central government has been authorized to frame a scheme, given the provisions. Accordingly, a scheme has been formed for the purpose of implementation of the act. That scheme is called as the Employees Provident Fund and Fund Miscellaneous Act, Fund Scheme, 1950. Now, below, section 6A has some bearing. Purport of this section 6A is that there shall be a scheme for providing pension to members of the Provident Fund. The basic thing of the scheme is that contribution of the 8.33% of the contribution of the employer's contribution shall be diverted to a fund called as Employees Pension Fund. Pension Fund. And that scheme was formulated in the year 1995.
This is over and above number 5, section 5.
Section 5.
This is in addition to section 5.
No, addition to section 6.
6.
It is within that. The total corpus remains the same. It's a part of that.
Oh, well,
Yes.
may I read section 6A? It's called as Employees Pension Scheme. Central government may, by notification in the official gazette, frame a scheme to be called the Employees Pension Scheme for the purpose providing for superannuation pension, retiring pension, or permanent total disablement pension to the employees of any establishment or class of establishment which act applies. And widow or widower's pension, children pension, or orphan pension payable to the beneficiaries of such employees. Now, notwithstanding anything contained in this section, there shall be established as soon as may be after framing of the pension scheme, a pension fund into which there shall be paid from the time to time in respect of every employee who is a member of the pension scheme. Now, who is contributing? A. Such sum from the employer's contribution. Go only from the employer's contribution. Under section 6. So, under section 6, employer is liable to contribute 10% or 12% as the case may be. A portion of this employer's contribution will be deposited to the pension fund. That is the content. Such sum from the employer's contribution under section 6 not exceeding 8 1/3% of the basic wages or dearness allowances and the retaining allowances, if any, of the concerned employees as may be specified in the pension. The employer is liable to pay 10% and 12%, and out of this 10% and 12% contribution here, 3.33% will be deposited to a fund that is called as pension fund. Such sums are payable to the employers of exempted establishment. That is very much important. That is the crux of the problem of this case. Because so far the refinery is concerned, it is an exempted establishment. Such sums are payable by the employers of exempted establishment under subsection 6 of section 7. This is the much important. Subsection 6 of section 17. The net asset of the employer's family pension on the date of the establishment of the pension fund. Such sum as the central government may, after due appropriation by the parliament, may by law in this term. Because apart from the contribution to be given by the employer, central government shall also contribute something. And at present, this contribution is 1.16%. That will constitute a pension fund. Now, what is the exempted establishment? Now, we are pursuant to this section, it is called as Employees Pension Scheme 1995 have been formed. So, we are having two schemes. One is Employees Provident Fund Scheme 1952, and second one is Employees Pension Scheme 1995. These two schemes are to be considered. Now, another thing is that your lordship come to the provision of section 17. Now, the scheme of this section that the employer may frame a separate provident fund. That provident fund is more beneficial than the provident fund scheme formulated by the central government. Now, we have an act called as Employees Provident Fund Act, 1950. In order to implement this act, central government has framed a scheme. That scheme is called Employees Provident Fund Scheme 1952. And in this scheme, there is certain provision, detailed provisions how the provident funds are to be administered. Now, this act has made a provision whereby some employer may frame their own provident fund scheme. If scheme is more beneficial than the scheme formulated by the central government. One example I make. There is a limit of contribution. That limit is contemplated under Employees Provident Fund Scheme.
your salary may be 1 lakh. But so far the provision fund is concerned, for the purpose of the computation of the contribution to be made by the employer and employee, there should be a limit. And this limit is fixed from time to time. At present, this limit is 15,000.
You were employees under
What you will define.
refinery.
What refinery has their own, they have their
So
own
it is an exempted.
exempted, that is permissible under section 17. I will come to that provision. That scheme is more beneficial than the scheme formulated by the Employees Provident Fund Scheme in 1952.
You had opted for that scheme.
Yes, they are opted for them. But so far that scheme is concerned, they are not totally exempted from the provisions of this Act. When the employer is permitted to frame a scheme by constituting a trust, but one thing is that though you can frame a scheme which is more beneficial to the scheme formulated by the central government, but you are not totally exempted from the provisions of this Act. You are to abide by certain provisions of this Act, then and only then you will be permitted to frame your pension scheme, provident fund scheme. Now,
Is there any specific order set by the
yes,
Provident Fund Authority?
yes. It must be approved by the Regional Provident Fund Commission. Now that is the provision that is constituted under section 76. Sorry, section 70. Now we have to come to section 70. Appropriate government may, by notification in the official gazette and subject to such condition as may be specified in the notification, exempt, whether prospectively or retrospectively, from the operation of all, that is very much important, from the operation of all of the provisions of the any establishment of any scheme. Number A, establishment which this Act applies, if in the opinion of the appropriate government, the rules of its provident fund with respect to the rates of contribution are not less favorable than those specified in section 6. So section 6 is 10% and 12%. It's not
Less
less
than that. Not lesser than that.
not lesser than that. The employees are also in enjoyment of other provident fund benefits. That is very much important. Apart from these benefits which have been conferred by the scheme formulated by the central government, the private employer or the employer may frame a scheme, but these schemes should contain other benefits apart from these schemes formulated by the appropriate government. Those specified provident fund benefits which on the whole are not less favorable to the employees than the benefits provided under this Act or any scheme. Scheme means Employees Provident Fund Scheme, 1952. In relation to the employees or any other establishment of a similar character. Number clause B. Or any establishment of the employees of such establishment are in employment of benefits in the nature of provident fund, pension or gratuity, and appropriate government is of the opinion such benefits separately or jointly are on the whole or whole not less favorable to any such employees than the benefits provided under this Act or any scheme in relation to the employees in any other establishment or of a similar kind. So there is two provision clauses, clause A and clause B. Clause A tells about the provident fund benefits and clause B tells about the provident fund benefits along with the pension, etc. Yeah, the employer has promoted a scheme which provides certain pension or gratuity, etc. Then turn out to determine etc. Now, here there is very important. Provided that no such exemption shall be made except after consultation with the central board, which on such consultation shall forward the views on the exemption of the appropriate government within such limit as may be specified in this scheme. Where an exemption has been granted to an establishment under clause A of subsection 1. So, Miller, our case is covered by clause A of subsection 1 because the Gauhati refinery does not have any pension scheme separately. The provisions of section 6, that is very much important. The provisions of section 6, 7A, 8, and 14B shall, so far as may be applied, so far shall apply to the employer's exempted establishment in addition to such other conditions as may be specified in the notification granting such exemption. And where such employer contravenes or makes default in complying with the said provision of conditions or any other provisions of this Act shall be punishable under section 14. And if the said establishment had not been exempted, as if the said establishment had not been exempted under the said clause A. So the he is bound by the provisions of section 6, section 7A, 8, 14, and 8, 14B, etc. Number, what is section? Section 6. Section 6 I have already read. Section 7A, 8. 7A. Oh, he is exempted, but he is amenable to this section. Now, what is section 7A? Determination of monies due to from employers. The Central Provident Fund Commissioner and any additional Central Provident Fund Commissioner and Deputy Provident Fund Commissioner, any Regional Provident Fund Commissioner or any Assistant Provident Commissioner may by order, in case where the dispute arises regarding the applicability of the Act to an establishment, decide such dispute. Determine the amount due from the employer under any provisions of this Act or scheme or the pension scheme or the insurance scheme as the case may be, and for any aforesaid purposes may conduct inquiry as may deem necessary. The office of, so for the other things are concerned, in what manner the inquiry is to be conducted. Now, your lordship, come section.
Once here.
Defense is very simple.
You were employees of an exempted.
Yes, let me giving the grievance, your lordship may finally go to the provisions of section 17, subsection C. Then it will be clear. 6. subject to the provisions of subsection 1C of the employer of an exempted establishment or an exempted employees of an establishment to which this provision, to which the provision of pension scheme apply, shall, notwithstanding any exemption, that is very much important, notwithstanding any exemption granted under subsection 1 or subsection 2 of the pension fund, such portion of the employer's contribution to the provident fund within such time and such manner as may be specified in the pension. Subject to the provisions of subsection an exempted employee of an establishment to which the provisions of the pension scheme apply shall, notwithstanding any exemption granted under subsection 1 or subsection 2, pay to the pension fund such portion of the employer's contribution to its provident fund within such time and in such manner as may be specified. Now, again, let us.
Unless they're exempted under 1C. Unless they're exempted under 1C.
Once. So let us come to the one provision once. Once is not a criminal one. Yeah.
Subsection 6. Subsection 6, they will continue to pay subject to the provision of 1C.
At all. Now, 1/6 is that the appropriate government may by notification in the official gazette and subject the condition on the pattern of investment of pension fund and such other condition as may be specified therein, exempt any establishment or class of establishment from the operation of the pension scheme if the employees of such establishment or class of establishment are either members of any other pension scheme or the process to be members of such pension scheme where the pensionary funds are at par or more favorable than the pension scheme. When there is a provision for the investment of the pension fund, that is the benefit. Not the case of but body while it not is. Now let us come back to again to section 6, section 5, section 6A, and 2 schemes. Now section 6 says that an employer and employee is liable to contribute either to the 10% or 12% as the case may be to the provident fund. All right. Now, section 5 says that there shall be a scheme be formulated by the central government for the purpose of implementation of the Provident Fund and Miscellaneous Act 1952. All right. Now come to section 6A. Section 6A says that central government shall frame a pension scheme for the benefit of the employees who are the members of the Provident Fund. And accordingly, a scheme has been formulated. That scheme is called as Employees Pension Scheme 1995. I will refer it later on. And now, who will contribute this pension scheme? Not the employer, not the employee. Only the employer will contribute the pension scheme to the extent of 8.33% of their deduction, of their contribution, sorry, 8.33% of their contribution towards the pension fund.
Where is it provided? Percentage?
That percentage fine. One third percent.
6 to 8.
6 to 8. Not exceeding 1%. Apart from that, the central government is also contribute something from that will depend on the decision of the government taken from time to time. At present, this is 1.6%. Now, an establishment is exempted from the purview of this act. Then also, this establishment is amenable to the provision for the Provident Fund Act. That is indicated by the section 17. And section 76 makes it very much clear that even if the establishment is exempted from the purview of the Provident Fund Act, then not under section 1C, then you are liable to pay your due contribution as if you are not an exempted establishment. That is specifically stated, as if you are not exempted establishment. Now, whose scheme has been formulated? I will just, without referring any condition, taking the answer, I will just shortly, I will just all the scheme. Now, one scheme is Employees Provident Fund Scheme 1952. Now, your Lordship, go through that scheme. There is a provision contained in paragraph 26, subparagraph 6, whereby a limitation has been imposed. Whatever be your salary, entire amount of your salary will not be considered for the purpose of contribution towards the provident. Certain portion of the salary will be considered for the purpose of the contribution towards the provident. And this ceiling limit is changing from time to time. Initially, it was rupees 300 when Act came into. Thereafter, on several occasions, I have narrated in my petition, on several occasions, it has been changed from this to that. And at present, it is 15,000. And prior to that, it was 6,500. Now, what is the benefit of this exempted establishment? Now, this exempted establishment may not apply this limitation. They may allow the employee's contribution towards his entire salary. And they will contribute the entire their contribution on the salary of the employee. That is the benefit. Now, I have annexed the copy of the trust rule. Now, let us come to first Employees Provident Fund Scheme 1952. That is framed under section 5 of the Employees Provident Fund Act. First, paragraph 26
Section 26.
No, Employees Provident Fund Scheme 1952. Was formulated in terms of the provision contained under Section 5 of the Provident Fund Act. Employees Provident Fund Scheme, the Lordship will get it at page 56.
Yes.
Page 56. Now, here it is there, in exercise of the power conferred by Section 5 of the Employees Provident Fund Act 1952, the central government hereby frames the following Employees Provident Fund scheme, namely, these are the relevant provisions. Now, at present, I would like to invite your Lordship to have an attention on paragraph 26
Scheme.
of this scheme. Chapter 4. Ah,
Membership.
membership, page 18. Class of employees entitled and required to join the fund. Now here, 1A, every employee employed or in connection with the work of a factory or other establishment to which this scheme applies. So far the Gauhati violation is concerned, this scheme is applicable. I have stated in my petition.
Yes.
I have stated in the relevant provision. And it is every employee is employed in the connection to a factory or other establishment to which this scheme applies, other than the excluded employees, shall be entitled and required to become a member of the fund from the day of this paragraph came into force in such a factory or other establishment. Now, let us keep up these for the time being. Let us straightway come chapter 6. Notwithstanding anything contained in this paragraph, an officer not below the rank of Assistant Provident Fund Commissioner may on joint request in writing to the employee of a factory, other establishment to which this scheme applies, an employer enroll such employees a member, allow him to contribute more than 15,000. Meaning thereby the limit is 15,000 actually. 15,000. More than 15,000 of his pay per month if he is already a member of the fund. Thereupon, such employee shall be entitled to the benefits and shall be subject to the condition of the fund, provided that the employer gives an undertaking in writing that he shall pay administrative charges payable to shall comply with the statutory provisions in respect of such. So, meaning hereby below, so far the scheme is concerned, the employee contribution, there is a ceiling limit. However, this ceiling limit can be lifted with the approval of the concerned authority mentioned there. Now, but so far the provision fund under the trust rule is concerned, the exempted establishment is concerned, there this ceiling limit is not applicable, and then need not take any approval whatsoever. They can take away. But one thing that should be bear into mind, so far the provision fund concerned amount is concerned, they can take the entire contribution on the entire salary, but they shall not deposit their contribution towards the pension fund beyond 8.30%. purport of section 76. Well, sentence from object the provisions of subsection 1C, the employer of an exempted establishment or an exempted employee of an establishment to which this provision of pension shall apply, shall notwithstanding any exemption granted under subsection 1 of subsection 2, pay the pension fund such portion of the employer's contribution to this provident fund within such terms and such manner as may be specified in the pension. Means that this contribution has not been specified. They are depositing their due contribution as contemplated under section 6(2)(a) toward the provision, not the contribution. They are contributing this, and there is a ceiling in. But there is direction sought for that is to that effect. No. Your prayer in the writ petition is primarily I will come to this point. Now, so far the order of 18/125 is concerned, what they want to say that we have trust rule. We cannot go beyond the trust. Beyond the trust rule. At page 210. For scheme, 11%, and the pension scheme. Then probably it will be clear. Clarification on policy issues related to proceeding of pension on higher wages. I will come to this higher wages. Before going to that, we will come to let us clarify these higher wages. Your Lordship, please come. Paragraph 11 of Pension Scheme, 1995. Number 203. Universal. Is Pension Scheme 1995. It's referring to the number of the bearer. Bearer. Now, this scheme was provided under section 6(a). And the pension provident fund scheme is provided under section 5. Now, employees pension scheme 1995. In exercise of power conferred by section 6(a) of the Employees Provident Fund and Miscellaneous Provisions Act 1952, the central government hereby makes the following scheme. This is the scheme. Now you should come to paragraph 3, Employees Pension Fund. That's from bearing here. From and out of the contribution, what is Employees Pension Scheme 1995. From and out of the contribution payable by the employer, only employer's contribution, in each month under section 6 of the Act or under the rules of the Provident Fund of the establishment which exempted. They have their own rules. I will come to that. Which is exempted either under clause A or clause B of subsection 1 of section 17. Just now I have read it. Clause A and B of the Act, or whose employees are exempted under paragraph 27 or paragraph 27A of the Employees Provident Fund Scheme 1952, a part of contribution representing 8.33% of the employee's pay shall be remitted by the employer to the employee's pension fund within 15 days of the close of every month by a separate bank draft or check on account of the employee's pension fund's contribution in such manner as specified in this behalf by the commissioner. The cost and remittance shall be borne by the employer. The central government shall also, we are here, the contribution of the central government. The central government shall also contribute at the rate of 1.16% of the pay of the members of the employees' pension scheme and credit the contribution to the employees' pension fund, provided that where the pay of members exceed 15,000, because there is a limit of 15,000 at present, provided that where the pay of the member exceeds 15,000 per month, the contribution payable on his pay of 15,000 only. So even if my salary is 1 lakh, but the contribution shall be 8.33% of 15. There is a ceiling limit. And this ceiling limit is varying from 10 to 10. At present, the ceiling limit is 15,000. This provided that where the pay of members exceed rupees 15,000 per month, the contribution payable by the employer and the central government be limited to the amount payable on his pay of 15,000 only. Now, look, one thing I will, as far as pension fund is concerned, pension fund's employer's contribution shall be confined with the rupees 15,000, 8.6% of the. What is it? But if the employee establishment is exempted, the employer's contribution towards the provident fund may be the entire 10% of the entire salary. That will be clarified when I will go to the trust rules. That is the basic difference. Now, your lordship, come to paragraph 11. Termination of
There are 11 scheme.
employees pension scheme. So, what this scheme is concerned, pension will not be paid on the basis of the entire salary drawn by the employee at the time of his retirement. But there is an exemption, and we are in that case. That is one higher scale. That is our case. Determination of pensionable salary. The pensionable salary shall be the average monthly pay drawn in the manner including the prescribed basis during the contributory period of service in the span of 60 months preceding the date of the exit from the membership of the pension fund, and pensionable salary shall be determined on pro-rata basis for the pensionable service up to the 1st September of 2014. Subject to the maximum of 6,500 rupees per month, and for the period of thereunder at a maximum 15,000 rupees per month. So, whatever your salary is there, it don't be more than 50,000. That has been clear. Now, let me skip it off. Provision 3. Now, provision 3, subpara 3. Seven. Here is the problem that has been pointed out by my learned friend when he has started his argument. The maximum pensionable salary shall be limited to 15,000 per month. There were some provision and that has been deleted by the year 24. So, oh, sorry. Yes. Ah, yes. Number 5, no? Proviso omitted by, provided that if at the option of the employer and the employee, contribution paid on salary exceeding rupees 6,500, at that third quarter it is 6,500 per month from the date of commencement of this scheme, or from the date of the salary exceeds rupees 6,500, whichever is later, 8.33%, shall be the employer thereof is remitted into the pension salary shall be based on such higher is remitted. Now, there was a provision whereby the employees on employer contract were allowed to exercise their option. Whether they will contribute their provident fund to the extent of their full salary. That option was given in the year 19. 96. In 1996, that option was given. If the employer exists, yes, I am agreeable to contribute my contribution towards the entire salary, then that can be done. And for that purpose, employee concerned shall exercise their option. And employer shall also agreeably exercise that they are agreed with it. Then and only then this is it. Now below that provision below, there was no time limit that in what period this option has to be exercised. As a result, large number of employees had not exercised their option in the year 1996 when this provision. But subsequently in the year 2005, I will give it to you. 2005, they exercised their option. They exercised their option. But their option was not considered by the Provident Fund Authority. And thereby, my lord, number of cases were filed in defined high court. And all this high court has specifically stated that as there is no time limit prescribed in that rule, to allow the employee concerned to exercise his option to the extent that they are agreeable to pay their contribution on the entire salary. So ultimately, this case went to the Supreme Court. After that judgment, they have modified their scheme as contained in paragraph 11.3. And this 11.4 was included. Judgment is here. Now let us 11.4. Member members. The existing members on the existing members as on first day of September 2014, who at the option of the employer and employee had been contributing salary exceeding rupees 6,500 rupees per month, may on fresh option to be exercised jointly by the employer and employee to contribute on salary exceeding 15,000 rupees per month for the existing members who prefer such option shall be based on higher salary. Provided that aforesaid members have to contribute, provided that the aforesaid members have to contribute at the rate of 1.6% of the salary exceeding 1,000 as an additional contribution from out of the contribution payable by the employees for each month under the provisions of this Act of the rules made therein. 1.6% is the contribution of the central government, and that central government contribution made by the employees concerned. Provided further that praise option shall be exercised by the manner within a period of 6 months from the day of 1st September 2014. Now there is a cut-off date. Provided also that the period specified in the second proviso may on the sufficient cause be shown by the members be extended by the Regional Provident Fund Commissioner for a further period of not exceeding 6 months. Provided also that if no option is exercised by the members within such period, including the extended period, it shall be deemed that the members not opted for contribution over wage ceiling and the contributions to the pension fund made over the wage ceiling in respect of the members shall be diverted to the provident fund account of the members along with the interest declared on under the employees provident fund scheme from time to time. I've got this judgment, but I will refer it. From section paragraph 11.3 and 11.4, there is a difference. When the 11.3 came in force, the employer and employee was granted to exercise their option. But there is no such time limit was prescribed. But from the year 2014, this time limit was granted, was imposed for a period of 6 months. The person concerned now exercise their option within the stipulated period, they approached before the defined time. Now, High Court allowed their repetition. Provident Fund Authority went to the Supreme Court. Supreme Court is the judgment of the High Court. Because of the fact, so far 11.4 is concerned, there is a specific indication to the effect that you must exercise your option within a period of 6 months. As you could not exercise this option within a period of 6 months, so your option will not be considered. That is the judgment of the Supreme Court. However, so in exercise of their power conferred under Article 146, time by 6 months, so that the Provident Fund Authority may frame a rule in here. If I not refers earlier paragraph 11.3, now I got it. Now, this way, when I have started this thing, let me finish. Now, that Supreme Court judgment is also annexed in my history. Now, this judgment I have annexed, it is at 100. Page 100. And relevant direction is 142. I should have referred earlier judgment, but the relevant practice I will refer later on. One 45. accordingly hold and direct the provisions contained in notification number such and such dated 22nd August 2014 are legal and valid. That is section paragraph 11 and 4. 11.4, the Lordship will come to paragraph 11 of the pension scheme. That is valid. Seven four at page 208 of this BR Act.
Yes.
7.4, that is with effect from 22nd August. I could not 6 note GSN number 609E 22nd August 2014. Not 609. Yes, relevant written judgment 145.
Yes. These are the conditions that
This is GSR number 309, etc. This is the 11.4, paragraph 11.4.
yes.
The provisions contained in the notification such and such date legal and valid. So you cannot challenge it. You have to exercise your option within the stipulated period. So far as the present members of the fund are concerned, we have read down certain provision of the scheme as applicable to their case, and we shall give our findings and direction on those provisions in the subsequent subparagraphs. Amendment to the provision of the scheme brought about by the notification number such and such dated 24 August 2014, that is 11.4, shall apply to the employees of the exempted establishment. So the refinery, Gauhati is applicable to the Gauhati refinery. In the same manner as the employees of the regular establishment, that is unexempted establishment. Transfer of funds from pre-amended paragraph of 11.3, because I could not refer fully, 11, I will refer it. Pre-amended paragraph 11.3 has also amended paragraph 11.4 of the pension. There was uncertainty as regards the validity of the post-amendment scheme, which was quashed by the aforesaid judgment of the High Court. High Court has quashed the judgment. Thus, all the employees who did not exercise option but were entitled to do so, but could not due to the interpretation of cut-off dates by the authorities, ought to be given a further chance to exercise their option. The time to exercise option under paragraph 11.4 of the scheme under these circumstances shall extended by a further period of 4 months. We are giving this direction in exercise of our jurisdiction under Article 142 of the Constitution of India, rest of the requirements as per the amended provision. So here, so far the 11.3 was concerned, earlier 11.3 is concerned, that has been upheld by the Supreme Court. I will refer to the judgment. There was no such cut-off date. Person concerned can exercise their cut-off option at any time. But so far 11.4 is concerned, there is a cut-off date. Rest of the requirement as per the amended portion shall be complied with. Now, 5. the employees who had retired prior to September 2014. So this 7th pool was inserted on 2nd September, August 2014. Without exercising any option under paragraph 11(3) of the pre-amendment scheme have already existed from the membership thereof, they would not be entitled to the benefit of this right. The person concerned who retired prior to 141, but they have not exercised their option, no, they will not be entitled to this judgment. But the person concerned who has not retired on that date, they were in service, they are entitled. The employee, he has been cleared. The employees who have retired before 1st September 2014 upon exercising option under paragraph 11(3) of the scheme 1995 shall be covered by the provisions of the paragraph 11(3) of the pension scheme and as to prior to amendment of 2014. The requirement of the members to contribute at the rate of 1.16% of their salary to the extent such salary exceeds rupees 15,000 per month as an additional contribution under the amended scheme is held to be ultra-virus to these provisions of 1952 Act. But for the reason already explained above, we suspend the operation of that part of our order for a period of 6 months. So, to enable the authorities to make adjustments in the scheme so that the additional contribution can be generated from the sum of the legitimate source within the scope of this Act, which could include enhancing the rate of contribution of the employer. We are not speculating on what steps the authorities will take, as it would be for the legislature or the framers of the scheme to make necessary amendments. For the aforesaid period of 6 months or till such time any amendment is made, whichever is earlier. The employee's contribution shall be a stopgap measure, and the said sum shall be adjustable on the basis of the alteration of the scheme that may be made. We do not find any flaw in altering the basis for the computation of the pensionable salary. We are agree with the view taken by the division bench in the case of R.C. Gupta. I have to refer this to Supra, so far as the interpretation of the proviso to paragraph 11(3) pre-amendment pension scheme is concerned. The fund authorities shall implement the direction contained in the said judgment within a period of 8 weeks, subject to our direction contained earlier in this paragraph. So, this is the amendment case, Miller. That is R.C. Gupta. It's a short judgment, Miller. In 2018 for 14 SPC, the last portion of the mic. Let us start from paragraph 2. The fact lies within a short campus. Under 1952 Act, 10% or 12% of the basic wages, including dearness allowance, etc., is required to be deposited in the Provident Fund account of an employee, being the employee's share. The Act as enacted in the year 1952 did not contain any provision for pension. Section 6A, which, with which we are concerned, was inserted by an amendment with effect from 16/11/1995, providing for employees' pension scheme to be framed for the payment of pension to the retiring employees. The corpus of the pension fund was to be inter alia constituted by deposit of 8.33% of the employer's contribution under Section 6 of the Act. The pension scheme was framed to give effect to the provision of the Section 6A contained inter alia clause 11, which deals with the determination of pensionable salary. Under clause 11(3) of the pension scheme, the maximum pensionable salary was limited to 55,000, which was subsequently enhanced to 6,500 per month with effect from 8/10/2001. A couple of months after, the pension scheme was framed with effect from 1995, 16/11/95. A proviso added to the clause 11(3) with effect from 16/3/1996, permitting an option. Here it is important. Permitting an option to the employer and employee for contribution of salary exceeding 5,000 or 6,500 with effect from 8/10/2001 per month. 8.33% of such contribution on full salary was required to be remitted to the pension fund. The appellant's employees on the eve of their retirement, that is sometime in the year 2005, they were retired in the year 2005, took the plea that the proviso brought by the amendment of 1996 was not within their knowledge and therefore they may be given benefit thereof, particularly when the employee's contribution under this act has been on actual salary and not on the basis of the ceiling limit, either 5,000 or 6,500 per month, as the case may be. This plea was negated by the Provident Fund Authority on the ground that the proviso visualized a cut-off date in exercise of option, namely the date of commencement of the scheme or from the date the salary exceeding the ceiling limit of rupees 5,000 or 6,500 per month, as may be. As such, as the request of the appellant employees was subsequent to either of the said dates, the same cannot be acceded to. Agreed. The appellant employees moved High Court under Article 226 of the Constitution. The learned single judge decided the writ petition in favor of the appellant employee, making it clear that the decision would not serve as a precedent for future. The division bench reversed the state decision, upholding the view of the Pension Fund Authority that under the proviso to clause 11(3), the pension scheme, there was a cut-off date. We have heard the learned counsel for the party. We have read and considered the order of the High Court provisions of the Act, Provident Fund Scheme, as well as the relevant provision of the pension scheme. Clause 11(3) of the pension scheme is the following term. Number 3. The maximum pensionable salary shall be limited to rupees 6,500 per month, provided that if the option of the employer and employee contribution paid on salary exceeding rupees 6,500 per month from the date of commencement of this scheme or from the date of salary exceeds 6,500, whichever is later, and at 8.33% of the share of the employee thereof is remitted into the pension fund, pensionable salary shall be on the basis of higher salary. So that option was granted in the year 1996 probably, when the 11(3) was inserted. But here there is no such time limit. Relating to the proviso, find that the reference to the date of the commencement of the scheme of the date on which the salary and the selling limit are the date from which the option exercise are to be reckoned for calculation of pensionable salary. The said dates are not, here it is clear, the said dates are not cut-off dates to determine the eligibility of the employees to get their option under provisory clause 11(3) of the pensionable scheme. A somewhat similar view that has been taken by this court in a matter coming from Kerala High Court, wherein the special leave petition number such and such filed by the Regional Provident Fund Commissioner was rejected by this court by order dated 31/6/2016. A beneficial scheme in our considered view ought not to be allowed to be defeated by reference to a cut-off date, particularly in a situation when the present case the employer had deposited 12% of the actual salary and not 12% of the ceiling limit of 5,000 or 6,500 per month, as the case may be. A further argument has been made on behalf of the Provident Fund Commissioner that appellant employees has already exercised their option under paragraph 26(6) of the Employees Provident Fund Scheme, paragraph 26 in the following term. I referred to. Notwithstanding anything contained in this paragraph, an officer not below the rank of Assistant Provident Fund Commissioner may, on joint request in writing, any employee of a factory or establishment to which this scheme applies, and his employer enroll such employee as a member or allow him to contribute more than 6,500 rupees of his pay per month. His salary is he is already a member of the fund, and thereon such employee shall be entitled to the benefit and shall be subject to the conditions of his fund, provided that the employer gives an undertaking in writing that he shall pay the administrative charge payable and shall comply with the statutory provision in respect of such employee. Because this is the earlier clause. Paragraph 26. We do not see how the exercise of option under paragraph 26 of the Provident Fund Scheme can be constituted to stop the employees from exercising the similar option under paragraph 11(3). If both the employer and employee opt for deposit against the actual salary and not the ceiling limit, exercise of option under paragraph 26 of the Provident Fund Scheme is inevitable. Exercise of the option under paragraph 26(6) is necessary. Persecution, exercise an option clause 11(3). Exercise of such option therefore would not foreclose the exercise of a further option under clause 11(3) of the pension scheme, unless the circumstances warranting such foreclosure are clearly indicated. The above apart the situation where deposit of the employer share at the 12% has been in actual salary and not a ceiling limit. We do not see how the Provident Fund Commissioner who have been agreed to file the LPA before the division bench, the High Court, all that the Provident Fund Commissioner is required to do case the adjustment of accounts, which in turn would be benefited some of the employees. At best, the Provident Fund Commissioner could do which the permit him to do under the present order to seek a return of all amount to that employees concerned may have withdrawn from their Provident Fund account before granting them the benefit of the proviso of the clause 11(3) of the pension. Once such return is made, whichever is case is returned in the due consequential benefit term is to be granted. But there was this concern in the earlier cases, as there was no out of that, the employee concern were allowed. But so far, the 11.4 is concerned, out of that, but now 6 month time for a window period, and accordingly, by the and are allowed to exercise their joint option. They are also allowed to exercise our joint option. We have exercised our joint. But one thing is that we have to pay 8.33% amount, actually limit of 8.33%. So remaining portion, say for 10%, we had not paid, that was not deducted. Players' contribution to the extent of 8.3% was diverted to the pension fund, but the employer's pension contribution to the extent of 10% was not diverted. Because of this option, that was not diverted, and that was deposited in our provident fund account. There is liability to pay 12% of our basic wage. Out of this 12% of basic wages, 8.33% is transmitted to the pension fund, and remaining amount will be deposited in our provident fund account. But that was deposited in our provident fund account. We were enjoying this amount. So we were called upon to pay the remaining amount which was in your account, provident fund account. Now, we were also called upon to pay the interest accrued on this amount. We were also called upon to pay the contribution to be done by the central government. That is 1.6%. And demand notices were issued. Those who have exercised their option along with the employer, and who paid the entire amount. Some person paid 30 lakhs, some are 34 lakhs amount. And after acceptance of that amount, we were allowed to enjoy the pension on higher salary, and that was continued. After elapse of some days, our pension on the higher salary.
Now, what specific direction?
Now, only thing is that is the here. Setting aside of 18 lakh. That is their case. Not my case. That's not what I think. That is what he is considering. My case is that they have passed an order. They say no order is there. Their case. That is their burden to come. Now you will have to come 18th year. 18/1/2025. We are challenging this. Page number 210. That is an order passed by the Additional Central Provident Fund Commission. And this order was challenged in different high court. Calcutta High Court Allahabad High Court, Madras High Court. All these three High Court has quashed this order. I will refer to that.
Now, Supreme Court has was considering the appeals arising in respect of disorder.
No.
Earlier.
Earlier. So far Supreme Court is concerned, Supreme Court consideration is that whether ceiling limit, cut-off date can be extended or not. Supreme Court was of the view, in two cases of defined view. So far 11C is concerned, there is no cut-off date, you can exercise your option at any time. But so far 11.4 is concerned, you cannot exercise your option at any time, but you have to exercise your option as per our order under Article 142. And we have exercised their option under Article 142, and that was also accepted by them, and they also granted us higher pension. And now this higher pension has been taken away, and they have been given lower pension. Now, what is their case?
There is a reference of trust. What are the trust?
Yes, I will come. That is the crux of the point. Now,
We already heard you for an hour, and you did not address
trust will be there.
where is the trust rule?
Trust will your lordship will find at page 68. Chapter 1, page 41.
41.
Sorry, page 40. Start with. Pensionable Corporation Limited Refinance Division Employees Provident Fund.
These are the trust rules.
Start with. That is rule framed under section 17, exempted. Basic scheme of this act, rule is that there shall be a trust vote. After the employers and employees provident fund contribution. Now, how benefit? One, 78. Yes. Box point is there. Now, here, these rules, why they are insisting on this rule, here. These rules shall not be altered. They are harping on this point. Shall not be altered or amended except with the previous approval of the Commissioner from the Income Tax and the Regional Provident Fund Commissioner, whom copies of such amendments to this rule shall be sent. The members shall have a right to appeal to the Regional Provident Fund Commissioner in case the Regional Provident Fund Commissioner approves any amendment to their disadvantage. Provided, this is the provision, provided further that any amendment, this is very much important, provided further that any amendment suggested by the Regional Provident Fund Commissioner from time to time in conformity with the Employees Provident Fund and the Miscellaneous Provisions Act 1952 and the scheme framed thereunder shall always be effective. Hereby, if there is any amendment, and that to be considered that it is from the other provisions of the provision. Let me read it again. Provided further that any amendment suggested by the Regional Provident Fund Commissioner from time to time in conformity with the Employees Provident Fund, Miscellaneous Provisions Act 1952, and scheme framed thereunder shall always be effective. The amendments are paragraph 11.3 pension rule, paragraph 11.4 of the pension rule. So it will automatically be enforced under the rules. Now, this is not only this provision. Your lordship will come to paragraph 26 of pension provident fund rule. Paragraph 27 AA.
Give us the page number.
Or page number. Page number is 84. Paragraph 27 AA. Terms and conditions of exemption. All exemption already granted or to be granted hereafter under section 17. This class 2 is framed under section 17. Under section 17 of the Act or under paragraph 27A of the scheme shall be subject to the terms and conditions as given to the appendix A. Appendix A is formatted. But now your lordship come to the appendix of this scheme. And at page 140. Now, following at the reverse, conditions of grant of exemption under section 17 of Act 1952. Let us keep all these provisions straight where your lordship come to paragraph 10, page 141. Any amendment of the scheme which is more beneficial to the employee than the existing rule of the establishment shall be made applicable to them automatically pending formal amendment of the rules of the trust. Now, that was amended by 11.3, 11.4, that is automatic. And in fact, Calcutta High Court, Allahabad High Court, and Madras High Court has relied upon this paragraph 26. Now you are lost it. Now you have come to page 210. The writ petition. That is the impending order. Certain policy issues were raised by the field office related to the processing of pension on higher wages. These issues were subsequently taken up with the Ministry of Labour and Employment for consideration and approval. The following clarifications are issued that have the approval of the Honorable Minister and Labour and Employment. Pension computation on pro rata basis, that is not relevant for us. Exempted establishments eligibility for pension on higher wages, POHW, to be based on the trust. Eligibility for pension on higher wages cases would be determined on the basis of the extent trust rule. Now this trust rule says it shall not be amended. Rule. To the exempted establishment in consonance with the direction of the Honorable Supreme Court in Sunil Kumar's case, the trust rules are amended as post decision dated on 4/11/2022. In Sunil Kumar's case, applications members of trust may not be considered. The eligibility of pension on higher case to be determined on the basis of the extent of trust. That is the idea. Of the exempted establishment in consonance with the direction of the Honorable Supreme Court in Sunil Kumar's case. Further, in case the trust rules are amended, post decision dated 14/11/2002 in the Sunil Kumar case, the applications of the members of subsequent shall not be considered. What is their conception is that you have to amend your trust. And if it is amended, then it will not be considered. On 45. The first reaction is not relevant. The provision contained in the notification, that is 11.4, are legal and valid. So far the present members of the fund are concerned, we have laid down certain provisions of the scheme as applicable to in their case, and we shall give our findings and direction on those provisions in subsequent subparagraph. Amendment to the provision scheme brought about by the notification dated 22nd August 2014 shall apply to the employees of the exempted establishment in the same manner as the employees of the regular establishment. Transfer of funds from the exempted establishment shall be in the manner as we have already directed. The employees who had exercised their exercise option under proviso to paragraph 11.3 of the 1995 scheme and continue to be in service as on 1st September 2014 will be guided by the amended provisions of paragraph 11.4 the members of the scheme who did not exercise option as contemplated from the Proviso 11.3 of the pension scheme as it was before 2014 amendment would be entitled to exercise the option. Those would be entitled, it has been very much clear that the person concerned who could not exercise their option, they will be also entitled to exercise.
You claim to fall under which category?
11.
Which direction? Seek benefit of which direction?
Paragraph 4. Members of the scheme who did not exercise their option as contemplated in the provisions to provision to paragraph 11.3 of the pension scheme as it was before 2014 amendment would be entitled to exercise option under paragraph 11.4. We had not exercised option 11.3. Now we are also entitled 11.4 of the post amendment scheme. There, the date of the judgment. Thereafter, the employees provident fund. You have to extend it.
Options were exercised.
Option exercise that was accepted, pension was granted to us. Subsequently, pension was, they have stopped the pension on the contention that which is against the due transfer, and you cannot announce that. That is the important. Now I have to refer three judgments. Three judgments against the which was this
We'll
order.
have to rise for today.
We were discussing while when my lord had written from the break, I my learned senior counsel, and I hope I'm not being quoted. Tomorrow at all be convenient.
I am second
Second,
or any other day.
what we consider 20th if possible. My lord,
I presume you're not from Gauhati.
I'm not from Goa, that's why
So
I'm.
Mondays, Wednesdays, and Fridays are incidentally.
If my lord will permit, we'll consult and notify the court master.